The cases sounded real. Martinez v. Delta Airlines. Varghese v. China Southern Airlines. Zicherman v. Korean Airlines. Each had a case number. Each had a judge's name attached. Each offered exactly the precedent that attorney Stephen Schwartz needed to support his client's case. The defendant's lawyers went to verify the citations. The cases didn't exist. None of them. Not a single one. ChatGPT had invented them, invented the names, the case numbers, the judges, the rulings, the legal reasoning. It had produced them with the same confident, authoritative tone it uses to discuss everything else. And Schwartz, a 32-year veteran of the New York bar, had submitted them to federal court without checking whether they were real. The judge who received the filing had questions. Stephen Schwartz was not a young lawyer experimenting recklessly with new tools. He graduated from New York Law School in 1992. He had been practicing for 32 years. He had a client, a man named Roberto Mata, who claimed he had been injured on an Avianca Airlines flight, and a case that needed research to support. The case had moved to federal court in the Southern District of New York. Schwartz was handling the federal filing, though he was not admitted to that court himself. His colleague Peter Loduca was admitted and served as the attorney of record. The research and drafting was Schwartz's job. He turned to ChatGPT. The idea, as he later described it, was to find similar personal injury cases involving airlines, cases that would support his client's position. He typed his queries into the chatbot. ChatGPT returned case names and summaries that fit the argument he was building. He incorporated them into his filing. He later testified, under oath, that he had not understood ChatGPT could make up cases. He thought it was a search engine. He thought the citations it produced were real. When the defendant's lawyers filed a brief noting that the cited cases could not be found, Schwartz obtained what he described as verification from ChatGPT. He asked the chatbot whether the cases were real, and ChatGPT confirmed that they were. It confirmed that fabricated cases, which it had invented, were real. Because that is what large language models do when asked to confirm information, they predict a plausible response to the question. The response that ChatGPT predicted was yes. The judge overseeing the Mata case was P. Kevin Costell of the U.S. District Court for the Southern District of New York. When the filing arrived on his desk, Judge Costell read it carefully. He then ordered Schwartz to produce copies of the cases he had cited. Schwartz submitted some. Others, he admitted, he could not find. He still did not reveal that they had come from ChatGPT. Only after Costell issued a second order, requiring Schwartz to show cause for why he should not be sanctioned, did Schwartz disclose the full truth. He admitted he had used ChatGPT. He admitted he had asked ChatGPT to verify the cases. He submitted affidavits describing, step by step, what had happened. The court held a public hearing on June 8, 2023. The courtroom was filled to capacity. An overflow room was set up with a video feed for those who couldn't get in. Judge Costell questioned Schwartz and Loduca under oath for hours. He asked about their decades of experience, their knowledge of legal research tools, the steps they had taken to verify the citations. The transcript reads, at points, as a precise documentation of how a professional operating with entirely wrong assumptions about a tool could fail systemically while being completely convinced he was working correctly. The core of what Costell established, Schwartz didn't understand what ChatGPT was. He treated a generative language model, a system that produces plausible text, as a search engine that retrieves real information. What Schwartz discovered the hard way is something engineers have known for years: large language models hallucinate. They generate text that fits the pattern of what's expected, regardless of whether the underlying content is factually accurate. When asked for case citations, ChatGPT produces case citations. The names, numbers, and summaries are constructed to sound real. Whether the documents they describe actually exist is a separate question that the model does not verify, because it cannot. This is not a bug. It is a fundamental characteristic of how these systems work. They are trained on patterns in text. They generate text that matches those patterns. Legal citation patterns are well represented in training data. The model produces convincing sounding citations because it has seen millions of them. The crucial mistake is treating plausibility as proof. A citation that looks right is not necessarily a citation that is right. Schwartz not only made that mistake once. He repeated it. When Costell asked for the cases and they couldn't be found, Schwartz went back to ChatGPT and asked it to confirm the cases existed. ChatGPT confirmed them. Schwartz submitted the confirmations. He was asking the source of a fabrication to verify the fabrication. And it verified itself, because that's what it does. On June 22, 2023, Judge Costell issued his ruling. He fined Schwartz, Lo Duca, and their firm $5,000. He required the two lawyers to send letters to every judge named in the fake citations, judges whose names ChatGPT had attached to cases those judges had never written. He required those letters to include a copy of the ruling, a transcript of the hearing, and a copy of the original court submission. The ruling was 34 pages. Costell wrote that he would not have imposed sanctions if the lawyers had been honest about their actions. The problem was not the original error. Errors happen in legal practice. The problem was the escalating cover-up, the repeated failure to disclose, the submission of affidavits to verify citations from the same source that had fabricated them. Schwartz's lawyers argued in his defense that he had already become, through the media coverage, the poster child for the perils of dabbling in AI. The judge found this insufficient reason to waive sanctions. The $5,000 fine was not the real cost. The real cost was what happened to the client. Roberto Matta, the man injured on the Avianca flight, had retained a lawyer who submitted fabricated case law in his federal filing. Whatever chance his case had, the Schwartz incident did not improve it. The Schwartz case opened a floodgate. Researcher Damien Charlton, at Heck Paris, began tracking court decisions where AI had been used in legal filings. By late 2025, the database contained more than 280 US cases and over 130 internationally. Lawyers were sanctioned in New York, Colorado, Arizona. A Denver attorney accepted a 90-day suspension from practice. A federal judge in Mississippi had to retract an order that contained AI fabricated information. A prosecutor, in November 2025, was found to have submitted briefs with AI-generated errors in a criminal case, not a civil matter, but a case where someone's freedom was at stake. In response, judges across the country issued standing orders. Some required lawyers to disclose when they used AI in court filings. Some required certification that AI-generated content had been verified. Some banned the use of certain AI tools without oversight. The pattern, despite the sanctions and the rules, was not slowing down. More lawyers were using AI. More of them were making the same basic error that Schwartz had made, trusting the output without verifying it. By the time Judge Costell issued his ruling, the legal profession was beginning to understand that the Schwartz case was not an outlier, it was an early example of a behavior that was becoming widespread. AI tools had dropped the cost of legal research dramatically. They were fast, accessible, and produced output that looked credible. Lawyers under pressure, working long hours, facing deadlines, were using them. Many were not checking the results. The problem wasn't limited to citations. In some cases, AI-generated briefs contained accurate citations but flawed legal arguments, arguments that sounded coherent but misapplied the cited precedents. In others, AI summarized case holdings in ways that were subtly wrong, reversing the outcome or overstating what a ruling actually said. These errors were harder to catch than fabricated citations, because the underlying document existed, the summary was just wrong. A judge who received a brief with an invented citation would catch it immediately. A judge who received a brief with a real citation and a mischaracterized holding might not without reading the original case herself. The harder problem was already spreading through the courts in ways that were much more difficult to detect. But on the other side of the same moment, Lynn White, who saved her home because she used ChatGPT carefully. Christopher Brock, who kept his shed. Hundreds of ordinary people, without law degrees, who had used the same tool more responsibly than the experienced lawyers who were supposed to know better. What separated them was not intelligence. It was the specific assumption each person brought to the technology. Schwartz assumed ChatGPT was a research tool that retrieved real information. He used it accordingly. He was wrong about what it was, and his mistake compounded until it filled a federal courtroom. White assumed ChatGPT was a starting point. She used it to understand, then verified independently. She was right about what it was, a language model that generates plausible text, not a database that retrieves facts, and she won. The irony that a first-generation AI user with no legal training understood the technology better than a 32-year attorney is not reassuring. It suggests that the danger is not ignorance of AI. It is expertise in a different field that creates false confidence about what AI can do. Consider the structural irony of the Schwartz case. Schwartz used an AI tool incorrectly and was sanctioned by a court. Lynn White used the same AI tool correctly and won her case. The court's response to Schwartz was to fine him and require disclosure rules. The court's response to White was silence. Her victory was not a legal precedent, it was a personal outcome that didn't make headlines. The legal profession's response to AI was almost entirely focused on controlling how lawyers use it. It had almost nothing to say about how ordinary people use it, whether those uses were accurate, whether the outcomes were just, whether a system in which legal knowledge is distributed by an AI that sometimes hallucinates is better or worse than a system in which legal knowledge is distributed only by lawyers who sometimes cost $350 an hour. That question remains unanswered. ChatGPT told Stephen Schwartz that the cases he needed were real. Then it told him the same cases were still real when he asked it to confirm. Then a federal judge asked him where the cases were, and they didn't exist. The judge was not angry about the technology. He was angry about what a lawyer does when the technology fails him. Does he stop and check, or does he keep asking the machine until it tells him what he wants to hear? Schwartz kept asking. The machine kept answering. Confidently. In complete sentences. With case numbers and judge names attached. Somewhere right now, a lawyer is asking ChatGPT for case citations. The chatbot is answering confidently. The lawyer has 30 years of experience and is under deadline pressure and will submit the filing in the morning. Some of those lawyers will check. Some of them won't. The machine doesn't know the difference. It will give the same confident answer either way. It has no interest in being right. It has no fear of being wrong. It just answers. That is a description of the technology, not an excuse for how it was used. Schwartz had 32 years to learn that sources can be wrong and that verification is not optional. The AI gave him a reason to skip that step. He took it. If a tool that sounds authoritative is confidently wrong, and the professional using it trusted the sound over the substance, who failed the client? If you think more people need to hear this story, share it. And subscribe, because this isn't the last time AI changes someone's life.